Good afternoon, everyone. We'll get started. It's the solicitor's office here. There we go.
Yes, sir.
Hi, Mr. Jordan.
Good afternoon, Judge Massey. The SAP reset date is May the 29th.
Okay. All right, good afternoon, everyone. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases which have been, individuals rather, which have been recently arrested and charged with certain misdemeanor offenses. Soon after the arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this is usually the defendant's initial appearance before state court judge, so we are going to address several matters that we're able to address, which include bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. Again, that reset date for the SAP calendar is May 29th. I want to begin by reminding everyone that this whole entire proceeding is being recorded, excuse me, as well as live streamed on YouTube, so govern yourselves accordingly. I also want to remind the defendants that you have certain constitutional rights. The first being that you have a right to have counsel or representation at this stage in your case. You should know who your attorneys are by now, and you should have spoken to them prior to court. You also have a right to remain silent. Remember that anything that you state about the facts of your case, the circumstances, the occurrences can and will be held against you. The state is here and they're listening. So again, follow the lead of your attorney. All right, who do we have first, deputies?
We can start with position 14 at South Annex, Mr. Moore.
Okay. All right, this is Jeremiah Moore, 25 CR 002707D, charged with one count of possession of marijuana less than an ounce. Second charge, possession of a pistol or revolver by a person under the age of 18, and also willful obstruction of a law enforcement officer. Pre-trial.
First.
Thank you. State.
Thank you, Judge Mincy. This incident date was May 15, 2025 at 663 Garibaldi Street, Southwest in Atlanta. Officers were traveling eastbound on the street. They noticed two juveniles at the intersection. Apparently they're brothers. He asked for their age and IDs. They both stated they were 17 and didn't have IDs. Officers said one of the juveniles matched the description of a suspect who took part in a robbery nearby. So he placed both juveniles in the patrol car, frisked both, ended up finding a tan 9mm Glock on the defendant that fell out of his pocket in the patrol vehicle. Defendant began resisting arrest and would not comply with officers' commands. Officers also found 10.56 grams of marijuana on him. Another juvenile came to the location. I guess this is another brother. Officers ended up detaining him as well after running the serial number on the gun. It came back as stolen out of Atlanta from January. Seeing as though this is a gun case, even though he's a minor, the state is looking for a $10,000 surety bond. That's $10,000 on the possession of a pistol and $250 on the willful and $250 on the marijuana. We're gonna ask for a curfew for him since he's under 18. We're gonna ask for a parent cosigner. I'm not gonna ask for a stay away from the intersection because I believe he lives nearby. His mother was included in the warrant, and she did make a statement that all three juveniles live with her. And no drugs, alcohol, or weapons while on bond.
So the state's recommendation is 10,500.
Yes, Your Honor.
All right. Which PD?
I've got that.
All right. PD McLean.
I've spoken to Jeremiah Moore, Your Honor, on the phone, and I've spoke also with his dad at the phone number that Jeremiah gave me. And I believe the dad has gotten a neighbor to help with zooming on. And I explained that there would be probably the court might be interested in a co-signing procedure. And he said that would be fine with him, that he would be responsible for supervising the young man and making sure he gets to court on time if the court allowed that. So we have no objection to a single bond. And we just got to figure out whether, if Your Honor is good with that, then we just need to figure out the procedure for the co-signing. He could actually co-sign in person and ink at the jail, or he could do it electronically if we could figure out an email.
Mr. McLean, does he live with the dad or the mom? Because the mom made a statement that all three of her sons live with her.
This interview today was based on a telephone conversation while driving, and so I wasn't taking notes. I believe that we covered mostly the legal procedure there. I don't know if he lives at the listed Windsor Street apartment 2, or if he lives with mom or dad. I don't have any problem with asking him directly as he sits there.
All right, let's ask him. Mr. Moore, Jeremiah Moore, who do you live with? They'll have to unmute you there at the jail. The deputy walk away? I'll ask Miss. Oh. Yes, can he answer him, the defendant answer a question, please? Can you unmute?
Okay, I'm sorry.
I
Sorry.
live
Okay.
I live at 570 Wynn Street, apartment 2.
Who do you live with?
My mom.
Are you going to live with your dad?
Nah, but I want him to represent me.
I'm sorry?
I want my dad like to get my co-sign me though. I live with my mom though.
All right, well, if your dad does that, he's responsible for you. So I don't want to put much on him. Let me talk to your dad for a second. And is mom on the call? What's your mother's name?
Charity Moore.
Say that again.
Charity Moore.
Spell her first name.
Sheridy.
Moore. Okay. All right, Mr. Johnny Moore, can you unmute, please? Mr. Moore, can you unmute your phone?
Your Honor, I'm sorry I'm late. I'm having some technical difficulties.
Oh, that's okay. I can see you now. Mr. Moore, can you unmute yourself so that you can talk? Maybe he can't even hear us. Did he fall off?
He had a neighbor take down the meeting ID and passcode. This is senior Mr. Moore's first time on Zoom, so this can get interesting.
My concern is having Mr. Moore to sign. He doesn't reside with him. I don't know how he control him. If the mother is the one, but did you state that she was charged also, ASG Dunlap?
No, it was three of her sons that all lived together. The two other sons were released, but since the gun in this case, he was kept. So they're all minors. It looks like one other one had a curfew as well. So
Mm-hmm. Just trying to figure out where the mom is.
yeah, I don't see her on Zoom.
Did he provide you the phone number, PD McLean, to the mother?
Not yet, Your Honor. We haven't reached the mother yet.
Well, I think
But
you're
I
gonna
think-
need to do it until Mr. Moore comes back and he can talk to me. I'm not going to have Mr. Moore to co-sign, especially if the defendant rather, is saying that he lives with his mom and not with his dad, but he wants his dad to co-sign on the bond. I'm not comfortable with that.
Certainly. Can South Annex chat, can South Annex put in the chat the mother's phone number?
He's holding it up. We can't see that. So you're gonna have to ask the deputy, can she type that in the chat?
Okay, Your Honor, that was just the South Annex dialing me, and of course I clicked on the button, so they just gave me the mom's phone number, and I'll just mute myself for a moment and call her.
Okay, we'll come back to him. I'm sorry, Deputy, until we get in touch with the mom. Before I make my final ruling, I want to see if she's the one that's going to co-sign. And Mr. Moore is gone. He hasn't come back in yet. So,
We'll see if we can get mom to zoom on. I'll be just a moment.
okay, thank you.
Thanks.
Let's move to another case and hold on more.
Go to position 1, Mr. Anderson at North Annex, Alpharetta.
Okay. All right, this is 25 CR 002702Y, Brian Anderson, charged with 1 count of simple battery family violence.
I've got the Anderson case as well.
Oh, well, I guess we could do it real quick, then you can go call.
Sure.
11
problem.
total. They got open
11.
criminal damage to property in Superior Court. It's 25 PI 000984. 2025 trespass, obstruction, arrest. Most of his history is DUI and marijuana possession.
All right. State.
Yes, Your Honor. State's going to ask for $1,200 surety bond for the simple battery family violence. The incident date is May 15th, 2025. Officer was dispatched to 3530 Schooner Ridge, Alpharetta, in reference to a domestic. And when the officer arrived, he met with the defendant, Brian Anderson, who was located outside the residence in the driveway with the victim, Barbara Anderson, who is his mother. And the defendant stated that his mom was texting him about an unknown female that the defendant is friends with, and his girlfriend found out. And the defendant expressed to his mom that he did not want her texting about the other woman because his girlfriend got upset. Now, the defendant stated that his mom was going to evict him. And the defendant later stated that he lifted his mom off the ground and set her back down. At the scene, the victim did not want to talk to officers. When asked about where he grabbed her, she said, I'm not going there at all. She stated she only wanted the defendant to go to work so he could have money, so she could evict him. Now, witness 1, his name is Todd, Todd, Bergeron, said he was doing some housework on the neighbor's house when he witnessed the altercation. And he said he saw a woman run out of the house, which was the victim in this case, and yell for help.
Thank you.
And the state is stated that the witness heard that she stated, he is going to hurt me. He also stated he saw the victim come outside the second time, and that's when he saw the defendant come out, picked her up, and brought her inside. The second witness, James Bodwell, said he heard yelling from the victim, and he saw the defendant drag the victim back into the house. He said he saw the defendant grab her shoulders and appeared to forcibly move her. A defendant has another prior violent arrest. I know that was 2001, 2 open DUIs with our office, has an open felony case. Defendant has been arrested 3 times in 2025. Now the victim is on the line, and our office was able to talk with her. She said she's dealing with that the defendant is dealing with some issues and wasn't taking some medication at the time. And the defendant is not a threat to her, and the behavior that day was the result of being triggered by his girlfriend. She states that the defendant needs his own space and shared that she is planning to arrange a stay at the stay lodge for him for a week so he can cool down. She stated she wants him to come home and not lose his job. The state is going to ask for a stay away to be a condition of the bond regarding this, and the stay away would be at the aforementioned location, and no alcohol, drugs, or weapons while out on bond.
What about contact?
What?
Excuse me, Ms. Anderson, I'm not speaking to you yet.
Sorry.
ASG Nixon, what about the contact recommendation?
The state's going to ask for no contact, just for a cooling off period, and then go from there.
All right. Ms. Anderson, do you wish to address the court today? Yes or no?
Yes.
All right. Raise your right hand for me.
Okay.
Do you affirm that the testimony that you're about to receive is about to give, rather, is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And put your hand down. Are you in fear of Mr. Brian Anderson, your son?
No.
Do you want to have any further contact with him?
Yes.
And you're arranging for him to stay away from the property?
Yes.
How old is Mr. Anderson?
42.
Okay. All right. Let me hear from his attorney. Figure out how to put yourself on mute because you've been interrupting me. We've been hearing you talking. It's a red microphone or something. Thank you. All right, go ahead, PD McLean.
Your Honor, 42 years old, high school graduate in 2001, has an accounting degree, a bachelor's degree in accounting, a BA. For at least, I always ask people the last 5 years at least of employment, and he's a manager at a retail store. He's missed 2 days of work or a day and a half or something, and is concerned about missing the third day. We would ask the court to grant the signature bond and also to put appropriate conditions as the court sees fit, but that's basically it.
You were looking for something else?
No, that's all.
That's it? Okay. All right, I'm going to order the $1,200 surety bond. I'm going to order that he stay away from the incident location on Affirmation Street, or not for sure the exact street name. He is to have no further contact with Barbara Anderson right now while he's on bond. He is to have no unprescribed medication or other drugs, alcohol, guns, or weapons while on bond. He is to stay medically compliant with any prescribed medications while he's on bond. Got to take his medication. Also, if we need to later amend the bond for contact, we can, but right now, I want no contact. And so I guess, Ms. Anderson, in order to set up this room and do all that, you need to have it facilitated by a third party so that your son won't violate his bond conditions and be back in jail.
Can I speak?
Yes.
Is there any way that he needs to get his car and to pick up his stuff? So can he do that without doing a third party or not?
Here's the way he can do that. He must arrange for a law enforcement escort once he is released, and they will meet him there, and he can have a one-time escort to get his personal belongings, his property, his car, but he can't come there by himself to get it. So his attorney
Okay.
will show him how to do that or tell him how to do that, and he can come with law enforcement to get those items.
Okay. I really hate that he's getting charged with this. I just don't feel that he's.
This is not the forum for that. This is a bond hearing. It's not his
Oh,
trial. You can talk to the
okay.
victim witness advocate or the state, but I am not dismissing or anything like that. So I'm not here to do that.
Okay. So I need to go
I didn't hear you.
through a bond company then or something to do that bond?
Speak to his attorney. I'm the judge, so I can't advise you on
Okay.
that, but his attorney can.
Okay. Thank you.
Okay. All right. Thank you.
Your Honor, were you able to get that address for the stay away?
No.
Okay. I'll repeat that. That'll be 3530. Schooner is going to be SCHOONER Ridge, and that's in Alpharetta.
Oh, I don't know where I got the street name I made up, but okay. Thank you for that.
Oh, good. No problem.
Hey, Judge Mincy, I will speak to this Miss Clemens, the victim advocate. I will speak to Miss Anderson again.
All right. Okay. Thank you. Miss Anderson, the victim witness advocate is going to call you, okay?
Thank you.
All right. Thank you.
Do I click on the attorney?
No, you're signing off now. We're done.
Okay.
Thank you.
Thank you.
Mhm. Mr. Jordan, can you help her out to sign her out. Thank you. All right, who do we have next, deputies? Are you, Mr. McLean, I think, went to make the phone call. So hopefully we can get a case that's not Mr. McLean's.
Yes, we can go to positions 3 and 4, Mr. Bellamy.
Judge,
I
that,
believe-
that was the case,
Good.
and I needed to speak to Mr. Bellamy. I was not able to reach him due to some other issues I had.
All right, deputy, can you arrange for him to call in?
McLeod interviewed him.
Okay,
Oh.
then good enough. Then
Oh,
McLeod.
good. I saw her, Miss McLeod. Attorney McLeod. She was on here. Is she still on, Mr. Jordan? She just walk away?
Which defendant is this, Your Honor? I'm sorry, I missed it.
This is position 3, Mr. Bellamy, but we're looking for Attorney McLeod, the conflict defender.
She's
I saw
still
her
signed on,
earlier.
Judge. She might have just walked away, but she is signed on.
She is on. Yeah, thank you.
Good afternoon, Judge. While we're waiting for Ms. McLeod's case, can we do position number 8, and that's for Mr. Murphy, Ms. Harris?
It depends. Who's he represented by?
Yasmin Harris, Judge. That's my client.
Oh, well, there's Miss McLeod. Can we-
Yes, Your Honor.
Yeah, can we circle back to her client, please? Which was Mr. Bellamy.
Bellamy, yes.
This is 23 CR 002705J, Stephen Bellamy, charged with 1 count of theft by taking, 2nd count of loiter and prowling.
7, 2024 FTA, 2022 battery not prosecuted, 2022 shoplifting conviction, 2019 attempted break and entering motor vehicle dismissed, 2019 simple assault dismissed, and a 2018 injury to personal property conviction.
All right, state.
Yes, Your Honor. This defendant, Stephen Bellamy, and I believe he has a co-defendant, Jared Davis, are companion cases, and they have 2 additional warrants added on each. I'll start with the current warrant in charges. That's on May 15th, 2025. That's the incident date. And on the state first is asking for a $2,000 surety bond for the theft by taking charge and a $500 surety bond for the loitering charge. And on Thursday, May 15th, 2025, an officer was dispatched to 266 4th Street Northwest. That's the Georgia Institute of Technology. This was the clogged undergraduate learning commons in reference to a stolen scooter. And upon arrival, the officer made contact with the reporting party. That's Mr. Benedict Berchisuyo, Georgia Tech student. And the victim stated that he arrived at the building on Wednesday, May 14th, 2025, and secured his scooter to a bike rack using a lock and chain. And when he returned on May 15th, he discovered the scooter missing and the lock and chain still attached to the rack. Now, the victim described the stolen scooter as a black Segway 9-bot and provided the serial number. And shortly afterwards, the officer received a screenshot of suspect observed taking the scooter, and the individuals matched the description of males previously detained in connection with a separate theft. Now, the officer noted that these suspects are known to remove scooters from wire locks by maneuvering them off the handlebars without breaking the locks. And the suspects enter the campus and are not students at the campus. And upon finding the males on 964 Marietta Street, Northwest Atlanta, the officer observed this defendant and his associate riding on the scooters that did not belong to them. And one of the scooters was determined to be the one stolen from the victim mentioned earlier. The scooter was a black in color Segway 9-bot with the same serial number that the victim provided. The defendant here, with regard to the shoplifting and the other concerns here, has an issue with taking or harming others' property. For his criminal record, he has 3 cycles out of North Carolina, 4 cycles out of Georgia, The state is asking for no further contact with the victim and to stay away from the Georgia Tech properties, no alcohol, drug, or weapons while out on bond.
What's your bond recommendation?
And that was $2,000 surety bond for the theft by taking charge and a $500 surety bond for the loitering charge.
All right.
And Your Honor, I am receiving information that the victim either wants a scooter back or refund it. But I want to make the court abreast of that.
All right, so restitution, do you have that amount?
I don't have the amount, but let me talk with my office.
Okay. All right.
It was 600, Judge. I'm actually on the phone with the victim now.
Oh, okay. Thank you.
You're welcome.
All right. Attorney McLeod?
Yes, Your Honor, good afternoon. My client
Good
is
afternoon.
35 years old and he lives here in Atlanta. He tells me that the scooter that he was riding was one that he had bought from Facebook Marketplace. I noticed that the state has not said, neither does the warrant say, since there were two people who was riding the scooter that was apparently stolen. It is my client's contention that the scooter he was riding was one that he had bought from Facebook Marketplace. And I believe that maybe this missing scooter was being ridden by the other person. But that is his position, that the one he was riding was bought from Facebook Marketplace. Your Honor, my client is not in a position to pay for a bond. And he tells me that he has two small dogs that were left in his apartment when he was arrested, and he's really concerned about them because it's been 2 days now. He doesn't have anyone who can go to tend these dogs, and he's thinking that by the time he gets out, his pets will be dead, Your Honor. He did express to me how concerned he was about that. So I'm asking the court to consider a signature bond for him. Nothing further, Your Honor.
And if I may briefly mention, Your Honor, both the defendants have been caught on camera getting the scooter, so we have evidence.
All right. There's a second case from who's not muted.
Oh,
Hello. Someone's not muted. On the second case, which has an incident date of 4/17/25, there's two theft by taking charges. I didn't realize he had two cases. Position 4 as well. Are you representing him on that too, Attorney McLeod?
That would be my presumption, Your Honor.
Okay.
Although I did not receive the warrant on that one.
You did not?
Right.
On this, I will order the surety bond, as the history is not impressive to me, and I want to make sure that he understands he's got to find some other means here. And I know these are accusations. I'm going to order a 2,500 surety bond on this case here. I'm going to order him to stay away from Georgia Tech. And that's a vast, large area, but stay away from any properties that have Georgia Tech on it. Going to be a big, big area of downtown. Since he's not a student there, find somewhere else to go. And so that'll be 2,000 on the theft by taking, 500 on the loitering. No drugs, alcohol, weapons, or guns while on bond. And no further contact with the victim, the Georgia Tech student. And now let's go to the second case. And on the second case, that's 25 CR 002717J with Stephen Bellamy, charged with 2 counts of theft by taking. And I've heard the history, so go ahead, state.
Yes, Your Honor. Incident date here is, I believe, April 17th, 2025. Now, on April 18th, 2025, the officer responded to Cloudman Residence Hall about a call to take regarding a reported stolen scooter. The officer met with the victim. This victim's name is Fletcher Machanda, last name Machanda, who was one of the reporting parties. Mr. Machanda stated he was working at the IPS T2 building on the 14th Street. So he parked the scooter at the Southeast Bike Rack facing the bus stop. And while he returned after working, the scooter was gone. The victim's scooter was a $400 Turbo ANT X7 Max scooter, black in color. Then there was a second victim, and a Rudy Molly, I spelled the first name and last, first name ANIRUDH, Molly MALLI, stated that on April 17th, 2025, he parked his scooter, locked the scooter up, and when he returned, it was gone. Now, his scooter is a $600 black Phantom Go scooter. Officer responded to the building and spoke with the security on scene. The security officer was able to pull up on cameras. Officer observed two black males, both Stephen and the co-defendant Jared Davis, ride up on a scooter and attempt to remove a different scooter. When they were unsuccessful removing the scooter, then attempted to remove the other. They were able to remove the scooter from the rack by jimmying it off, and the two males then rode off on the scooter. So in summary, they stole one scooter, and after 38 minutes, they came back to steal the other scooter. So it was two scooters in all here. And you've already heard the criminal history. Stays asking again, no further contact with the victims here. Stay away from all Georgia Tech properties. No alcohol, drug, or weapons while out on bond, and restitution.
All right. Ms. McLeod?
Yes, Your Honor. As I was saying earlier, my client is not in a position to pay bond. His biggest concern now are his two dogs that he has in the house, Your Honor. They've gone 2 days already. Nobody's been there to turn them, to take them out to party or to feed them. He's concerned that by the time he gets the opportunity to get out of jail, that the animals will be dead. So I'm just asking on humanitarian grounds that the court consider signature bond for my client. Nothing further, Your Honor.
Well, yes, history is not very good. I'm concerned about the dogs, but he'll have to try to see if maybe his attorney can help him out with that. I'm going to give him a $2,000 surety bond, $1,000 on each of the theft by taking charges. It's a $2,000 surety bond. Stay away from Georgia Tech, all the Georgia Tech properties and locations. Stay away from the campus. No drugs, alcohol, weapons, or guns while on bond, and no further contact with the victims in this case.
Thank you, Your Honor.
Thank you.
Yes, Judge. We have next position number 8, Ms. Harris.
I'm ready, Judge.
Okay. This is 25 CR 002710E, Yasmin Harris, charge of 1 count of battery.
Third arrest, 03, theft by receiving dead doctor.
No,
That's it.
thank you. State.
Yes, Your Honor. The state is requesting a $1,000 surety bond for each of the battery charges, so that would be a total of $2,000 surety bond. The incident date is April 18th, 2025. On April 19th, 2025, officer was dispatched to a call for information on a fight. And when the officer arrived, he met with the victim, Miss Takita Roberts, and she stated that the day prior, on April 18th, 2025, at 4 p.m., she went to the park located at 3114 Collier Drive, Northwest. When she was there, she stated that she encountered someone who used to be her friend, the defendant, and the victim stated that they got into a verbal altercation. Now, after the altercation, both females went their separate ways. Now, the victim stated that as she was walking away, Miss Harris, the defendant, came from behind and started to hit her. She stated that she does not know what she was hit with, but everything happened pretty fast. So the victim also mentioned that there were 3 other people with Miss Harris, but she does not recall if they were involved or not. The victim stated that she called 911 when she was at the park, but no one showed up. And Miss Roberts also stated that she went to the hospital, Grady Hospital, around 6:30, and the victim had her right eye bruised, swollen eye. It was really swollen shut. She also stated her back was hurting and she had some scratches on her back. On May 10th, 2025, while conducting a patrol, officer received a radio transmission regarding a wanted female suspect identified as the defendant. And the officer observed a white Infiniti which matched the vehicle description, signaled the vehicle to stop, and arrested the defendant. You've heard the criminal history. The state is asking for no further contact with the victim in this case, Takeda Roberts, anger awareness, no alcohol, drugs, or weapons while out on bond.
Mr. Murphy? Attorney
Judge,
Murphy?
Judge, my client is age 46. She has no real history. Your Honor, there was an incident at that park. My client defended herself. She thought that was it. In addition, my client had actually applied for and received a protective order against this person, this alleged victim. My client is employed with FedEx. My client does not work anywhere near this alleged victim. My client resides at 3942 Bakers Ferry Road, Atlanta 30331. She's been employed at FedEx for approximately 2 years. I'd ask the court to consider a signature bond. As you've heard, she was picked up. This was all unbeknownst to her. And again, she had sought and received a protective order against this alleged victim. And now she spent several days in jail. And we'd like to have her out on signature bond. She can return to work. And again, she doesn't work with this alleged victim. This dispute perhaps is from a gentleman that perhaps they may have had some sort of association with. But again, my client will honor the terms of the bond and stay clear of her and not have any contact with this source of possible conflict, this gentleman. But again, my client also has 2 children, an 18-year-old and a 7-year-old. So we want to be able to come out and take care of the family as well, Judge. So I would ask the court to consider a signature bond there.
Can you give us some information so we can see the order that you're talking about? I thought I looked and I didn't see anything.
My apologies, counsel. I'd only gotten it today. I did not have time to circle the wagons and get that documentation, but I certainly will get that to you.
Well, okay. There was a petition for an order and it was dismissed.
Okay, my client thought it was signed on May 6th. Perhaps she was mistaken.
I see a dismissal of an order in March of 2025.
I believe she said she applied for one right around April 16th.
Why?
Another one. Looks like a final order in 25 CV 00511B from May the 7th.
Okay.
So that would have been
Before the bike.
before this incident.
Exactly. You look dumb.
Excuse me, Miss Roberts.
I didn't say, be quiet.
Ms. Roberts, who is that?
I believe that's the purported victim in this case, and obviously the other party who needs to maybe find something else to do. These individuals should have no contact with each other whatsoever.
Mm-hmm. And so we do or don't have a TPO order?
I'm looking at a temporary protective order that was issued May the 16th, April the 16th, when Mrs. Harris applied for an order and was given an emergency order, and then a final hearing was set for May the 7th. It's not clear whether the respondent was present for that hearing. but a stalking 12-month order was put in place May the 7th. So we'll circle back and look at that, Your Honor.
Okay. All right. Well, at least I can go ahead and rule on this case. I'm going to order the $2,000 signature bond through pretrial. I'm going to order her to go to 2 days of anger awareness classes through pretrial. I guess I'll put her at a level 1. She can call in and have no further contact with the victim, Nikita Roberts. And I don't know, do we want to stay away from the incident location? But I think it was just, was it walking down the street,
It's
or do
just a
we have
park.
an address? Just a park?
Yeah.
All right. Won't do that, but no unprescribed medication, drugs, or alcohol, guns and weapons while on bond. And I guess that'll be it. Anything else, counsel?
Judge, we appreciate the grace of the court allowing signature bond.
Okay, you're welcome.
Nothing from the state, Your Honor.
Thank you, Judge. Judge, I have a quick announcement.
Yes.
Question number 11, they waived their appearance. It's Cornetta Jones.
Okay,
And that's it, Judge. We're completed here at ACDC. Thank you.
thank you.
Judge, on that last case, was that 1,000 per charge on the signature bond?
Oh, yes, uh-huh.
Thank you.
And I thought I saw Mr. McLean. Were we ready to circle back or not? But now I don't see him.
Judge, as a housekeeping matter, does Ms. McLeod also have Jonathan Churn?
I do.
Okay, then that's all I have, Judge.
All right, have a good weekend.
Thank you, Judge.
Uh-huh,
And we can go to position 5, Mr. Churn.
okay. This is 25 CR 002715G, Jonathan Churn, charged at 1 count of battery family violence and 3 counts of cruelty to children in the 3rd degree. Actually, 4 counts of cruelty to children in the 3rd degree and 1 count of willful obstruction. So is that 1, 2, 3, 4? There's 6 charges. ASG,
Yes, Your
Allen?
Honor.
Okay, 6, okay. All right, and let's see, pretrial. What do you have on Churn?
I have that history, Your
Okay.
Honor. This was a case that was originally in the felony in the DA's office, but for some reason was reduced and sent to us, transferred to us. This is an incident from November. The defendant was arrested April the 3rd. His criminal history includes a prior battery family violence and a prior aggravated battery family violence with cruelty in the 3rd degree associated against the same victim and children out of DeKalb County, which is why this was initially in felony superior court. So based on the statute, it should be a felony, but for today's purposes, that information is applicable for our bond consideration. The defendant has 2 prior convictions for violence against the same victim. Her name is Erica Johnson, E-R-I-K-A. A police report was made on November the 17th, 2024. On scene with the victim, Mrs. Johnson. She was seen to have bruising or swelling on her face and then bruising and lacerations on the inside of her mouth. She reported that the father of her 4 children who were present there at the time had repeatedly struck her in the face, causing this laceration inside her mouth and bruising on her face and swelling on her face. He also slapped her more than 5 times, she reported, on November the 9th, and had punched their son in the chest during that incident, their son Julian specifically. The report details follow-up with domestic violence investigator Jay Brown Tony with APD, multiple interviews and conversations with the victim where she elaborated that the lacerations that were caused by this defendant on the inside of her face because he struck her multiple times in November caused it to hurt and have such a hard time. She's unable to eat on that side for a period of time. Her mother, the grandmother of these children, was also spoken to. Warrants were obtained on November the 20th, so 4 days after the incident, 2024. And then the defendant was eventually picked up April the 3rd, 2025. Basically, since his arrest, he's been in constant contact with the victim, calling her from the jail. Instructing her to write an affidavit, say you're not in fear, you no longer wish to pursue this, that you're okay with me having a bond, and you can even tell them I want an ankle monitor. He then gets on the phone with two of their children. They use different names for some reason, Mark and Eve, and tells them also to let the court know and write a letter saying that they're not afraid and that they want their daddy to come home. It is of note he had also a cruelty in the first degree case. From April 11th of 2024 for striking the same child, Julian, in his body. He spoke to that child during the same jail calls on the 28th of April. This is one of many, many calls, and tells him about that case and that he also needs to write a letter. Your Honor, so the children are all named in each accusation. There are 4 of them specifically, date of birth starting 2/10, 2/11, 2/16, and 2021. We're asking for a $15,000 surety, Your Honor. No contact with Mrs. Erica Johnson or any of the children with the last name Churn. I don't believe they're married. No drugs, alcohol, or weapons. We would request an ankle monitor as well as DVIP to begin enrolling and start participating.
All right. So that's 6,000 on each, 36,000.
I said 15, Your Honor.
Okay, give me the breakdown.
Let's see.
15,000 total, but 6 on the battery, I heard. No?
No.
Oh, okay. Didn't hear that. So give me your recommendation again.
We would ask for 8 on the battery. And then 1,000 on the obstruction and the other to be on the cruelties. There's a substantial issue here with repeated assaults against the same victim, coercion and control, attempting to suborn perjury and statements by her in order to make it so he has no consequence for his behavior. There are multiple prior convictions against this woman for violating and assaulting her in front of her children. He has had multiple arrests for assault on the children specifically. The defendant is not only a danger to the victim, but a danger to these children and frankly, anyone else in the community at this point. And that's why we're asking for a surety and an ankle monitor. Thank you. If you'd sound for Mrs. Johnson in case she was instructed to be here today.
All right. Miss Erica Johnson? Nope. All right, go ahead, Miss McLeod.
Yes, Your Honor. My client has been in jail for some time. He is not in a position to pay for bond. He specifically asked if the court would consider giving him a signature bond. He is the father of these 4 children, Your Honor. He has legal custody of them. I don't believe the state mentioned, but he and the alleged victim have been in a relationship for over 15 years. So that is some considerable time, and they do share these 4 children. He denies the allegations as stated in the warrant, Your Honor, and he said they were just having a disagreement over the children. He denies what the state is saying, that he struck her multiple times in the face, Your Honor. Even if the court is disinclined to give him a signature bond, I would certainly ask for a much reduced bond. He definitely is not in a position to pay for a $15,000 bond. So he's just going to be sitting in jail waiting if this bond is not made more reasonable or a signature bond. Also, this alleged incident happened last year, Your Honor, about, by my calculations, about 6 months ago. So I would like the court to take all of this into consideration in setting a bond for my client. Nothing further, Your Honor.
If I could just clarify, he had warrants within 3 days of this assault in November, and he just wasn't picked up until April. And he has been in custody in no bond status. So not only does he have prior convictions against this young woman, I'm not sure what him having custody of the children means, if that's out of Fulton County or DeKalb County. I can look into that. Please share. But I don't have any information that the biological mother of these children doesn't have custody of her children. He's been sitting in jail with no bond until today because the case was transferred to us. And again, I'm unclear why it was transferred to us because it seems very clear that we have visible injuries, an assault on this victim that was witnessed by multiple people, recorded statements to officers about being assaulted and how she couldn't chew as a result of it, an assault on a child at the same time, coercion and calls from the jail, as well as a serious criminal history. So I'm not sure why it was here, but he has been in no bond status rightfully until the DA decided to transfer that case to us.
Just because he was in no bond status doesn't mean he can't get an appropriate bond now, because it is
I don't think it
now
is.
a misdemeanor.
I'm not
Because
arguing that he shouldn't get a bond today.
right, the
It's just
DA may,
disingenuous to say this happened a long time ago when in fact
it
he was
did.
out with active warrants and that he hasn't had a bond for some reason other than the fact that the case is so egregious a judge wouldn't give him one because he asked for one. He petitioned the court for a bond in this case multiple times and was told no. So
I
that's the reason
understand.
why he's in no bond status. It's just important to make all the facts on the record.
I understand. What I'm saying is, it is undisputed that he has been sitting in jail without bond for some time. So therefore, he has been unable to work. Since he's not working, it puts him in a position where he's unable to pay for a bond. That was the point I was trying to make. Had it been a situation where he had just come in, one could say he probably would be able to. But I'm just telling you that based on his financial circumstances, he would be unable to make bond because he's been locked up for some time. And also, it did happen in November. So, and these are people who have significant history together as a couple, well over 15 years. My client is 38. They've obviously been together since they were both quite young. I don't know anything about any calls or any of that, but I'm just asking for either a signature bond or a much reduced bond for my client so he can get out of jail. Nothing further, Your Honor.
All right. I'm not for sure what it'll take for Miss Johnson to feel safe. Usually when they come back and they've violated the previous orders, we do a cash bond so that he can understand he needs to leave this woman alone.
We would not object to a cash bond, Your Honor.
Your Honor, I do not think my client has some history, but it's not like a recent history at all. This was a long time ago.
You're honestly
Previous
like
history
whether
with
it's
that.
recent or not, the fact that he has violent convictions for a battery and an aggravated battery against the same victim, they still create this case being a felony and they're relevant today, regardless of when they happened. Them
I
being in a
understand.
relationship for 16 years is what you're using as an argument for why, people get in fights. They love each other. They've been together a long time. You can't then argue that because he assaulted her and was convicted for it in 2011, 12, and 13, that that's too remote to have any value here today. They're valuable. They are reasonably
And they may well be valuable. I'm just saying it's a long time ago, and they share 4 children. But I think that is significant. It says something about the enduring nature of their relationship. We may not like what happened there, but I'm just saying they obviously have stayed together for 15 years. And it's not like they've had a constant history of, this kind of stuff. This happened last year, and that is also a fact. In November of last year, that is when it's alleged that this happened. If my client receives a very high bond or a cash bond, he just cannot pay it. I'm just stating something that is a fact because he's been locked up for some time. So I'm asking the court to take that into consideration. Nothing further.
All right. I'm going to issue the 15,000 surety. And that'll be 8 on the battery, 9, 10, 11, 12, 1,000 on the cruelties, and I thought 2 on the obstruction. Let's check my math. 10, 11, 12, 13. Is that 14,000?
Yes, Your Honor. We're still missing 1,000. If you could do 9,000 on the battery, 4,000 on each of the cruelties, and 2 on the
Now let's
obstruction.
do that. 9 on the battery and then 1,000 on the others.
Your Honor, if I may say, it sounds like this is more punitive than anything else. He's really not in a position to pay for bond. This is, after all, a misdemeanor. It was determined to be a misdemeanor by the DA's office. After they sat on it for a while, were able to look at the allegations, they came to the decision that this was a misdemeanor. And his bond just does not sound like a misdemeanor bond. It sounds more like a felony bond. And it sounds extremely punitive, given the fact that he's been sitting in jail for all this time and that this incident happened 6 months ago. I'm just asking the court to take that in consideration and to cut the suggested bond by at least half. The 15,000 is very high, Your Honor. And
Well,
I know that
actually,
is
that
not
doesn't
enough.
sound like the felony bonds. The felony bonds are much higher than that, actually. But I'm very concerned that continues to get cases with the same victim and in front of her children. I don't know that he deserves much leniency at this point. And I guess for whatever reasons, they did not want to prosecute it as a felony. But I just think, and you say he's been in jail all this time. What's the arrest
Your
date?
Honor.
April the
ASGL?
3rd.
April the 3rd. Well, I'm going to stick to the 15,000 surety, just due to the nature of the circumstances as well as the repeated history. You know, sometimes they say, well, because there is no case, maybe things were cooled off and didn't happen. Sometimes it's just because the victim is just as tired and frustrated of continuing to come to court and maybe feels like that the system is failing her. And she stopped calling the police. I don't know. But I'm going to stick to the 15,000 surety and no drugs, alcohol, weapons, or guns while on bond. He's to have no further contact with the victim, Erica Johnson, and or her children, and to stay away from her place of residence as well as where she works.
Your Honor, my client tells me that he has custody of the 4 children. Is it possible for him to have third-party transfer of the children?
I see a attempt to establish child support out of DeKalb County. I don't see a final order. I don't see anything in Fulton County where this address is and where she lives. So I would love to see something related to the biological mother of these children having her parental rights taken away, but I don't see anything like that.
And where did he get custody from?
I don't know, Your Honor, but he told me
How
that he
did he
has
get
primary custody of them. So I'm just going by what my client shared
Where were
with
they
me.
married? Were they married in Fulton or
Yeah.
DeKalb?
I am not sure. My client wants to say something. Just say whatever you say. Let it be about the custody situation, okay?
Good morning, Judge. Last year at the time, Erica Johnson is currently on bond for person recruits the children. At that time, my parents had kinship. After the kinship later on last year.
So I guess the question is, what authority has granted you? So is it DFACS? Is it a superior court? Where is it?
Sounds like it might be defects because she is on bond on a
I
cruelty
would like to hear
charge.
his answer, but I got it.
After sitting down, DFACS granted me custody. All the paper was sent to the Goodman out of Georgia, out of the public defender's office. DFACS granted me full custody of my 4 kids.
What court?
Out of DFACS.
Defects, he said.
What's the kind of defects? They closed my case last year. They took, my parents had kinship, not the kinship. I won custody over my 4 children.
I'd love to see something to that effect. I don't see anything in Fulton County system related to that.
It was sent to the public defender's office, Superior Court. Ms. Goodwin has those emails.
Okay. Well,
And we don't see it though?
I don't see anything.
So he's
It's in
there,
custody.
and so they were married. I missed that part.
No,
And he hasn't legitimized them.
Yes, I think he's saying because she was charged with cruelty to children, at that point, these facts stepped in and gave the children to him.
And so at the time of this incident back in November, where were the children residing?
with her in her home.
With her in her home.
He says no.
Okay, well, I look forward to litigating this further, but at this point, I don't see anything that says the victim in this case from November, who is at home with her children right now, doesn't have custody of those children. I don't see anything that says this man ever married her or has been deemed the legal father of these children, period. I do see where he's been convicted for assaulting her in front of them, and he's got open cases for assaulting the children. That's what I see.
Excuse me, Your Honor. If I may speak.
One last thing.
If I may speak. Yes, ma'am. On the 23rd, those cases were thrown out by the prosecutor's office. The one she's referring to, I punted in the check. Those cases were dismissed on 4/14/2025. The children right now should not be around her. And also, an incident happened on 4/22/25. Ms. Goodman has information where an additional incident happened while she was on bond. For no violent contact, she struck the children and ended up leaving one to my parents' office. That's been documented since the public defender's office.
Well, it sounds like they shouldn't be with neither one of you, to be real frank about it. But I'm concerned if something, like that was dismissed or whatever in April, ASG Allen should be able to see that they were dismissed. She doesn't see that.
I see, well, the case we have in front of us was dismissed by the DA's office. I do see that Erica Johnson has a bond order that says she shall have no further violent contact with the same child that this gentleman is accused of assaulting. Nothing about it saying she can't have contact with her children or that they've been taken from her custody. And that is
that
July 2024, which is before our incident here.
For this one, yeah. So she's just supposed to have no further violent contact, which we tried that with you as well. The more we talk, the messier it gets, and these poor children are the most serious of victims, going every which way. I feel bad for them more than anything. So maybe you can just apply for a modification once we figure it out. But I just, nothing about this makes me feel good at all in trying to protect these kids, maybe from both parents at this point. But I'm going to stick to the dad on this because he's not legitimized him. I don't see, they may have given him some temporary custody at some point and then it went awry after that. I don't know. So we have 9 on the battery, 1,000 on the cruelty, 9, 10, 11, 12, 13. I'll bring it down to 14. So 9 on the battery and 1,000 on the others. 14,000 surety. And then the stay away and no further contact with her. I'm not going to order any third-party transfer of the children at this point. I'm not comfortable with that. So he should just no further contact with the kids or her until you all can sort it out, get some orders together, bring them back and ask for modification if we find out otherwise. That's the safest way at this point. All right, thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, have a good weekend.
You too, Your Honor.
All
Thanks.
right, thank you.
Mr. McLean, are you ready for, position 14 or should I move on?
I thought I saw him come back.
Yeah, you got to tell me. Come on, you know you can talk.
Mr. McLean, P.D. McLean, is he back?
If not, we can go to position 2, Ms. Anderson, Mr. Chatai explained.
Okay. '25 CR 002704E, Bridget Anderson, charged with 3 counts of simple battery.
Fifth arrest, got open stalking, unlawful conduct during 911 calls. Out of state court, ag assault, trespass out of Superior. 2014 disorderly conduct.
All right, state.
Yes, Your Honor. State's asking for $1,000 surety bond for each of the simple batteries. The incident date is May 15th, 2025. An officer was dispatched to 224 Ponce de Leon Avenue, Northeast Atlanta. That's the Mary Max Tea Room to a dispute. And upon arrival, the officer spoke with the restaurant manager. She said a woman, whom later identified as the defendant, attempted to enter the restaurant following two customers. And the host stopped her and told her that she could not go inside. Now, the defendant said that the 2 customers agreed to buy her food, and the host told her to wait and that she would confirm with the customers. The defendant did not listen and followed the host back. The host explained the situation to the manager. She requested that the defendant leave the restaurant. The defendant turned around and walked out. She grabbed a cart with silverware and menus. She threw them on the ground. In addition, she had a beer bottle in her pocket. She threw it toward 2 victims, Constance Perdue and Thomas Miller, and the bottle did not make contact with them. However, the liquid from it fell on them. The officer spoke with the defendant, who said she was on the sidewalk and saw the people who agreed to buy her food. She went inside the restaurant and employees went crazy and started attacking her. But the officer spoke with another witness, Dimitri Fowler, and victim, a security officer working across the street. He said he saw the employees coming out the restaurant arguing with the defendant. He attempted to de-escalate the situation, but the defendant spit on him. She was subsequently arrested. I do note, I believe the defendant is homeless. I have a 2015 disorderly conduct and 2021 criminal trespass was an ag assault arrest. And, the state is asking for a social worker visit, kind of addressing housing concerns, stay away from Mary Max Tea Room, no further contact with any of the victims, and no alcohol, drugs, or weapons while out on bond.
All right. PD Chatai.
Yes, thank you, Your Honor. My client would like to request a signature bond, otherwise the lowest surety amount that's reasonable for her case. She's 54 years old. I would consider her a local. She's lived in the Atlanta area since 2014. She got through school as far as the 11th grade and thereafter did 3 years of college in public relations. So I didn't ask her this, but I assume she got a GED in the meantime. Currently, she's unemployed. She hasn't had a job in the past 5 years, and she did tell me she was homeless. So I asked for a social worker to visit her. Given those considerations, Your Honor, and especially the fact that she wouldn't be able to pay the state's surety amount, those are the reasons for my request.
I hear your request. The problem is she's got open cases for some serious offenses. Stalking. And the aggravated assault and criminal trespass is open as well.
They're open, Your Honor, but they're not convictions.
I understand. I'm going to give her the $3,000 surety bond. 1,000 on each. No drugs, alcohol, weapons, or guns while on bond. stay away from the Mary Mac Tea Room on Ponce. And I guess no further contact with any of the employees there. I don't know if you want that or not.
That's agreeable with the state.
All right.
Likewise with the defense.
All right. Thank you.
All right, we can go back to position 14 at South Annex.
Okay. What have you found out, Mr. McLean?
The mom works right with a X-ray machine, so she's having to figure out how to step away from her department in order to Zoom on with us. She was trying, and she might be on by now. I do have an email for her.
Not a phone number?
I've got her phone number, and I've been talking to her. I'm sorry, I heard the court was. I was not on audio. I've been watching y'all. Sorry, I didn't hear my name called. But Your Honor, I think she'll either be on Zoom now. I did tell her that we do have court every day, but Sunday at 2, if it has to be put off. But with her email, I explained to her what was at stake in terms of supervising him, making sure he stays out of trouble, enforcing any curfew if the court were to grant one of those, if it was requested. But and making sure that he makes court on time. That is actually the language that's in what she would be co-signing in the thing that we send her and that she sends back. And she was asking if she can't use her email to do that, can she co-sign at the jail? I said, yeah, frequently we do have people just co-sign at the jail front door.
Mm-hmm. All right. I'm concerned. I guess Dad got off, never got back on. I wasn't impressed. I don't know if the Zoom scared him or what, but I don't, when children pick which parent they want, they usually pick the softer one and not the disciplinarian from my understanding. So, if I order him to be in the custody of his mother, since she's willing to do it, I guess, from your brief conversation with her, I just want to make sure of it. My inclination is to give him a surety bond, but, I know he's 17, but he's barking up the wrong tree here to end up, over next door in the felony court. What, is he still in high school? 17? He's got one more year to go, or what's the status with school? Because I would order that.
Mr. Jeremiah, speak up. Are you a junior?
Yeah, can you ask them to unmute you? Okay. I think he says yes, a junior.
He's off mute now. We apologize.
Okay.
We have his
Yeah, I'm in
mom on the
11th
phone.
Oh, his mom's on the phone?
I have her right here on the phone, right here because she can't get on Zoom. So she's on the phone right here at the jail.
Okay. Deputy, ask her if she's willing to co-sign that bond.
Are you willing to co-sign the bond for your son, Mr. Moore?
Yes, ma'am.
Okay, I can hear that. She will be able to control him, hopefully.
I'm on my job. I'm on my job.
Okay. My question was, will you be able to control him to get him back to court, ma'am?
She said, will you be
Yes,
the
ma'am.
judge? Okay.
Okay. All right, because he's going to have a curfew as well. She's got to be willing to enforce that.
Yes, ma'am.
Okay. All right. What high school does he go to?
He go Maynard Jackson.
Maynard Jackson? Okay. All right. Is he going to summer school?
Yes, ma'am. He is. He made good grades. He got good conduct. I can't explain. Yeah.
Well, he just maybe he's hanging out with the wrong crowd. So let's see if we can change that so we don't see him down here again. Thank you for your time. I know you're at work.
Yes, ma'am.
All right, talk to Mr. McLean. He'll explain to you how to get him bonded out. All right. So I'm going to order this 10,500 signature bond through pretrial per the judge, because I need some monitoring here as well. And I'm gonna have him at a level 2. And with that 10,500, I think it's 10,000 on the gun charge and 250 on the other two to make it 10,500. So what that says to you, Mr. Moore, is if you mess up and you get back in jail, your bond will start out at 10,500 and go up. All right. So you're going to be on a curfew. What's the other cases curfew? ASG. You said he had a curfew in another case or something else?
I'm sorry.
Yes, Dunlap. I'm sorry, forgot your last name. ASG Dunlap. You said he has a curfew in another case?
No, I think an additional minor, there's 3 of them, had a curfew, something in the warrant about that.
Oh, okay. The other juveniles that were with him.
Yes.
Okay. So
Other-
what we usually do, 7 a.m. to 9 p.m., something like that.
Does he have a job? Can we do 6 p.m.?
Oh, let's see. Yeah, Mr. Yes, shake your head or not, Mr. Moore. Do you have a job? Are you going to be working this summer? Where?
I'm gonna try to get a job.
You don't have one right now.
Nah.
And you have to go to summer school so you can graduate. You know that? Your mom just mentioned you need to go to summer school.
I don't need summer school.
What kind of grades do you have?
Right now, I'm filling a couple classes, but I was already ahead. Like my graduation course, I'm already ahead.
Okay, well then what, you shouldn't be getting in trouble then. Sounds like you're on track to go to college. So change your environment, okay? Change your friends. So-called friends, because they're just getting you in trouble.
Your Honor, I think those 2 are his brothers.
Oh, those, well, you gotta stop hanging out with them.
So we'll ask for the 6 p.m. if it can be like, I guess, adjusted if he gets a job later, but we'll ask for the 6 p.m. curfew till 7 a.m.
Okay. So we'll do 6 p.m. to 7 a.m. If you get a job, tell your attorney so he can make a motion for us to consider revising your bond conditions. But right now, I want you to be in by 6 p.m. and you can't go back out to 7 a.m. I'm also putting in the bond order that if you need summer school, you'll go. If not, you will go to school next year and graduate, be on track to graduate. That you will go to school, finish your schooling. No drugs, alcohol, weapons, or guns while on bond. Hopefully you're not trying to smoke marijuana, so that's a drug. It's illegal. So you shouldn't have any more of that. No, and let's see, he was in the streets, so we have no stay away place, right?
No, they were on an intersection, I believe.
In
so
an intersection, right?
necessary.
And so are we able to say no further contact with the co-defendant?
The other 2 weren't arrested. They were released, but those are his siblings. They all live together. It looks like they all have the same mom. So,
Gee, I wish I could say no, not necessarily violent contact, but no illegal contact with your brothers. They're leading you down the wrong road. You have good grades. You have an opportunity to not be in the system. So make wise decisions. And sometimes you have to tell your brothers, sisters, cousins, friends, no, I'm not doing it. Okay? As the saying goes, just say no. It's not just to drugs, no to criminal activity, no to.
Ask a question.
Yes.
Hey, will this charge, D-charge, like, I'm a felon?
I think I can't answer that. I'm gonna let your attorney address that.
Mr. Moore is really bright, and he's got legal questions. I'm going to discuss those with him. But
well, maybe Mr. Moore can turn his life around and join the club and become an attorney. Wouldn't that be great?
Sounds like he might. But I clarify one thing: the last 3 letters, I understand the spelling of Charity, and I understand the second half of the first part of the email for your mom is STAFFOFD, not ORD. So it's not Stafford. It's just different. And then that's a Gmail. So I think we've got the way of sending her the email.
What is her name?
Is she? I believe it would be
Charity.
Charity
Or
Stafford.
Charity. Yeah, spell it again, Mr. Moore, and I'm sorry, Deputy.
SHERIDYMOORE.
Okay.
Is their last name Moore or Stafford?
Maiden name is Moore. Wait, hold on.
Oh,
Well,
she's
what name is on
remarried.
her ID? That's what the jail is gonna need.
Stratford.
Main name
Maiden name is Steph.
is ST.
Well, she's still there?
She on the phone right next to me.
What's
Oh,
on her ID? What's the last name on the ID?
right.
What you say? Say it again.
Mom,
What name is on her ID?
More.
More.
Thank you.
Okay.
Can they check my
Okay.
ID? I only have ID.
Oh,
You say what now? You do or don't have an ID? Do you have a driver's license? Ask your mom. Does your mom have an ID or driver? I thought she said she didn't. And then I need to
She
move.
don't got a driver's license. She got ID.
Oh, she has a Georgia ID. And that has Moore as her last name on the Georgia ID?
Yeah.
Yes?
Yes.
Okay.
Yes, ma'am.
Okay, thank you. All right, so you got to make some very wise decisions, Mr. Moore. Good luck to you. And thank you, Ms. Moore. All right, that's it, council.
Thank you. Yes, that's everything.
Okay. Oh, Mr. McLean, send mom's phone number. Did you send that to Mr. Jordan so he can submit that with the records? He's got her name. He needs a phone number.
I did.
I have
Oh,
it.
you did? Okay. All right. Thank you.
Thanks.
Who we have next?
16, Alpharetta.
Okay. This is 25 CR 002711C. Is it Colin? Is it Slaughter? Charge at 1 count of theft by shoplifting. Pre-trial.
15. Got an open case out of Woodstock. Marijuana possession. Possession of a Schedule 1 controlled substance. Financial transaction card theft as of April. 2015 shoplifting conviction. 2014 shoplifting conviction. 2013 disorderly conduct conviction.
All right. State.
Thank you, Your Honor. This is Colin Slaughter, correct?
Yes.
Okay. This incident date is from February 15, 2025 at 1135 Woodstock Road in Roswell. That's a Target. Officers responded to a theft call from loss prevention. The defendant entered the store. He went to the music area, picked up 2 CDs, went to the toy area, picked up it looks like a Dragon Ball Z action figure. And then by the time he got to the end of the aisle, placed them in a plastic Target bag. He then passed all points of sale. When he got to near the front door, loss prevention stopped him, took the bag from him, and then he walked out and got his car. Loss prevention did advise him they wouldn't have called the police if he just came back to the office, but he still left and drove away. We're gonna ask for a surety bond in this case, just because he has a history of theft by shoplifting. Obviously wasn't able to upgrade this because one of them was a NOLO. The fourth one would have made a felony. So I'm gonna ask for a $1,000 surety in this bond. Surety in this case, I'm sorry. I'm gonna ask for a stay away from that Target, an anti-theft course if you're inclined, and no drugs, alcohol, or weapons while on bond.
All right. Mr. McLean.
Thank you, Your Honor. 33-year-old Mr. Slaughter does have a stable address in Marietta. The phone numbers are stable, Your Honor. He won't have any trouble getting to court. He has 3 years of college. He's working on his 4-year degree. He does inventory stocking, and he's also been the manager of a retail store. So we would ask the court to consider a signature bond if that is possible. But if not, then a 1,000 surety.
All right, I'm going to order the 1,000 surety. I'm going to order him to stay away from that target. I usually say stay away from all of them. I don't know if the state has a preference or just the one on Woodstock.
I don't know where the other thefts were, so I'm just gonna say stay away from this specific target for now, at least.
Okay. And no drugs, alcohol, weapons, or guns while on bond. And that'll be it.
Next is position 10, Ms. Jenkins.
This is 25 CR 0027128 Tawana Jenkins, charged with 1 count of battery family violence. I think it's just the 1 charge. Is that correct?
It's a third arrest, 2025 terrorist threats. That was DWAP, 2022 disorderly conduct NOLO.
All right. State.
Yes, Your Honor, the state has asked for $1,500 surety bond for the battery family violence. The date of offense, or the incident date, is May 15th, 2025. On this date, the officer was dispatched to 3396 Ross Drive in East Point in reference to a fight. Officers arrived on the scene and spoke with William Jenkins, the victim here, who stated that he was struck in the head by the defendant. The victim stated that the defendant was listening to music in the bathroom when he knocked on her door to tell her to turn the music down. The victim stated that the defendant did not answer the door the first time. So Mr. Jenkins, he then knocked on the door for a second time when the defendant opened the door and struck Mr. Jenkins with an unknown object. The victim stated he did not know what she had struck him with, but stated he thinks it was an object. Officers then took the defendant into custody. The victim had a cut on his forehead. The state wants to state that both the victim and the defendant live together. So we're interested in promoting a cooling off period between the two individuals here. You've heard the criminal history. I did note the 2023 NOLO to disorderly conduct, the 2025 terroristic acts and threats arrest. The state is asking for no further contact with William Jenkins for the time being, and stay away from the address 3396 Ross Drive in East Point, and no further, no alcohol, drugs, or weapons while out on bond.
And the victim's name again was?
Yes, his name is William Jenkins.
Are they related?
All I read from the report is that they live together. I don't know if we can ask.
They live together.
Yes.
Are they? So we don't know if they're married or related or what. Maybe Mr. McLean knows the relationship, or is it Mr. Chataya's case? Oh, you know the relationship?
I don't know their relationship. I only know that they live together.
All right. I'll let you present. You can ask the defendant, or because I do want to know that.
Okay. I'll present first, Your Honor. My client is 41 and a half years old. She's a lifelong resident of Atlanta. She finished high school, and she tells me that she's an entrepreneur with multiple businesses. She has one LLC. Well, I believe she has 2 businesses, actually. One of them deals with music and entertainment. The other one is for media platforms. So she does have strong ties to the community. Your Honor, I guess I would object to stay away since my understanding is that this is Ms. Jenkins' address, and would instead ask for no further violent contact order instead. Again, I'm not sure what the relationship is between Ms. Jenkins and the alleged victim involved in the case.
Okay. Miss Jenkins, can they unmute you? I want to ask, what is the relationship with you and William Jenkins?
Yes, ma'am. The relationship is he's my ex-husband's father, and that's
ex-husband's father. So he's your ex-father-in-law?
Yes, ma'am. That's my home. I was born to that home. That's my home. I was frauded by William S. Jenkins.
Okay, Ms. Jenkins, so all you needed to do is answer the judge's questions about the relationship. I advise you not to say anything about the case right now, since these hearings are recorded and listened to by the prosecutor. So whatever you say here can be used against you in a later proceeding.
All right, just stick to that. All right, so I don't know how old he is, but I'm assuming, does he have somewhere else to go live? How old is he?
80 years old.
80 years old?
But he's a
Well, I do slightly have a slight issue with that, obviously. If he's been living with her, but they're not getting along right now, I don't know if he has anywhere else to go. I don't normally put the victims out, and I don't usually allow the defendants to come back. There needs to be some cooling down. It's just happened. And I understand it's her place. I don't know, what his health condition is, if he's able to take care of himself, if she's the caregiver. I'm assuming that could be the issue. One last question, Ms. Jenkins, are you his caretaker?
No, ma'am, I'm not his caretaker. The charges was dropped.
Okay, she's not his caretaker. State, a slightly tough one. I mean, he's 80, maybe just fine, but I don't know. You all have not had any contact with him?
Let me check on that. But I don't think our office has, but let me check one.
No.
Okay. You haven't?
No, ma'am.
Yeah. Who are you, ma'am? Samsung, you're not on this case. Oh. That was your victim witness advocate speaking. I forgot. And that was the advocate that said, no, we haven't, or that was someone else?
Right, that was the advocate. That was our office.
Oh, so she did say you have not had any contact with them.
Right.
And I hate to ask Ms. Jenkins another question. Can they live together and not fight and get along? Has there been any cooling down? I don't know. You want to ask her that, Mr. Chataya?
At this point, I'd rather not, Your Honor. I'd rather that she don't answer any more questions.
Well, I'm going to have to, I'm going to grant the $1,500 surety bond. I'm very torn about whether to ask her to stay away and have no further contact with him. That's what my gut tells me to do, but I don't know. She said she wasn't his caretaker, so caregiver. So maybe he's able to function and get along. I'll let her go back as long as there's no further violent contact between the two of them. What do you say, State?
If we could just put this to the end of the calendar and take a minute to research. What the defendant said before she was muted was that her charges were dropped. The information we have is that she's got an 80-year-old gentleman living in her house. She just said she wasn't his caretaker. And we haven't been able to get in touch with him. So we would try to make another effort to do that, Your Honor.
Okay, let's do that. I'm very torn myself. I don't want to put him in any harm's way, or anybody for that matter, but I am concerned about his age and being in the home. Okay, we'll move it to the end. I think we have the other waiver too at the end. But who do we have next, deputies? Let's hold on him. Her, rather. I'm sorry. Her.
His position 6 and 7, Mr. Davis.
Okay. Right, the first case I have, and he has two cases, 25 CR 00270888. Gara Davis charged with one count of theft by taking, second count loiter and prowling, criminal trespass, and willful obstruction. And this is the case with the co-defendant named no, not Bellamy. What's the code? Yeah, was this Bellamy? Okay.
You got 4 total. 2024, carrying concealed gun, controlled substance that was dismissed. 2023 driving while impaired conviction. 2022 DWI dismissed.
All right, state. You can give me a brief synopsis. I kind of remember.
Okay, yes, Your Honor. State is
The
asking
ones
for,
at Georgia Tech.
yes, this is the Georgia Tech co-defendant. The
Right.
state is asking for $2,000 surety bond for the theft by taking, $2,500 surety for the criminal trespass, and $2,000 surety for willful obstruction, and a $500 surety for loitering. This is regarding the scooters that were stolen from Georgia Tech. I won't go into the facts. I'll just briefly abreast the court of some new facts. On April 25th, 2025, the defendant was seen on cameras taking an electric scooter from 266 4th Street Northwest. I believe that's still a Georgia Tech property. The defendant was issued a criminal trespass warning and banned from campus on April 25th, 2025. The defendant was caught on campus in the case in chief here on May 15, 2025 with this incident. Further, when the officers attempted to arrest him in this case, he did not obey lawful commands with the officer, especially after positively identifying him. He told him to stop and get on the ground. And then this defendant also proceeded to flee. He is a party to the crime for the theft of the victim scooter. This is Benedict Verchicio's scooter. That's from the May 15th case here. He's charged as working in concert with defendant Bellamy. Pretrial mentioned the cycles out of Georgia, but he has several theft-related cycles out of North Carolina, ranging from 2011 to 2021. Larceny, shoplifting, even simple assault. So the state is requesting no further contact with the victim, of course, stay away from all Georgia Tech properties, no alcohol, drugs, or weapons while out on bond.
And is that no contact with the co-defendant as well?
Yes, no contact with the co-defendant.
All right. PD Chataya.
Yes, Your Honor. My client is 24 years old. He's been an Atlanta resident for the past 10 years. He tells me that he is currently enrolled in college studying business administration and that he's also a part-time cook. He's been a cook for the past 3 years, supporting himself. He lives fairly close to Georgia Tech campus, but not that close. He tells me he is about a 5 to 10 minute walk away from the campus. Your Honor, since I'm not sure if he's enrolled in Georgia Tech, could we make the order so that if he's a student, he could keep going to campus, but otherwise, we would not object to the stay away. And
Okay. Can you ask him where's he enrolled? I'm curious. Is he enrolled in Georgia Tech or somewhere else?
Well, I enrolled in Scott.
What did he say?
Scott. I enrolled for Scott.
SCAD?
Mm-hmm.
Is that what he's saying, SCAD?
Yes, sir.
Oh. Okay. So not Georgia Tech.
Okay.
Okay. Because I don't want to put in there, he can go there if he's enrolled. I mean, I don't know. And I was just making sure he wasn't alleging to be enrolled in Georgia Tech. And anything else, and I may cut you off. I'm sorry.
Nothing else, Your Honor. My client just specifically would like to request a signature bond for both cases.
Your Honor, I don't know if pretrial mentioned or anything. I think I saw a probation violation FTA in 2024, just in case.
I'm concerned about the gun charge. The second case is again, are you gonna tell me the same thing you told me on the others, that they're on video?
Correct.
With the
Correct.
scooters? Yeah.
Same thing. States
Yeah.
asking for the $2,000 surety bond for each theft by taking charge in the same bond conditions.
So that's 25 CR 0027188. That one's on the 17th of April, and this one's 15th of May. I'm very, very concerned. He's young, 24. So on this first one, that's a total of 7,000. Yeah, you've asked for 7,000 on the first one and 4,000 on the second. So let me look. I think on the first one, I'm going to do 4,000 surety on the first. So that's 2,000 on the theft by taking, 500 on the loiter, and 2,500 on the trespass. Well, I have to take off maybe 1,500 on the trespass. So that'll be 2, 3, 4. Just trying to make it 4. So 1 on the theft by taking, 1,000, 500 on the loitering, 1,500 on the trespass, and 1,000 on the obstruction. Is that 4? Yes. You checking my math, Mr. Jordan? Or somebody checking my math?
What you saying?
Okay, so 1,000 on the theft, 500 on the lawyer, 1,500 on the trespass, and 1,000 on the obstruction. Is that 4?
45,
Yes.
I guess. 4? Okay.
4.
Thank you. All right, pre-child, you can't do the math for me. 4,000. Stay away from all Georgia Tech properties. No further contact with the co-defendants. No drugs, alcohol, weapons, or guns while on bond. Anything else, counsel, on that one? And then on the other, theft by taking, I'm gonna make that a 2,000 surety, 1,000 on each for position 7. Same condition, stay away from Georgia Tech. No drugs, alcohol, weapons, or guns while on bond. Okay. That's it.
Next is position 12, Mr. McCoy.
Your Honor, I think we have the victim from the last case on the phone regarding.
Oh, Julie, Mr. Jenkins?
Yeah, Mr. Jenkins.
Oh, that would be great.
Hold on, Mr. Jenkins. Let me put you on speaker, okay?
Okay, hold on. Can we get Miss Jenkins back? Deputies, I'm sorry. We have the victim on the phone. Which position that is? Let me see.
Position 10.
Thank you. All right, we have on the phone Mr. Jenkins.
Yeah.
Can you hear
I
me?
didn't understand what you said.
Okay, this is Judge Mincy. Can you hear me?
Barely. I think it's on
Barely.
my phone. I don't know where to turn it up there.
Okay,
I can hear you now.
I would ask you to raise your right hand. I'm sure you will. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, can you tell us your address?
It's 3396 Ross Drive, ROSS Drive, East Point, Georgia, 30344.
All right. How long have you lived there?
Close to 30 years. I don't know the exact years, but it's almost 30 years.
Oh, 30 years. Whose house is this?
Mine.
Is yours?
Yes, ma'am. I
So
became
it's not Miss Tawana Jenkins' home?
Oh,
Who's on the deed? Who owns this house?
me. Miss Jenkins Jr.
And then your son?
But one of my sons is still here. He's the oldest son, but her son is still here as well.
Okay, so she's your ex-daughter-in-law, though. She's divorced from your son?
Yeah, she's for my youngest son. Yes, ma'am.
Okay. How long has she resided there with you?
She's been here over a year.
Oh, that's all?
A little over a year. I don't know the exact dates on that, but it's been over a year.
Has she been helping you out or something?
No, they don't. They don't do anything. They don't work or contribute to do anything.
Okay. Are you in fear of her?
I mean,
Are you afraid of her, in fear of Miss Jenkins?
well, after this incident, I'm somewhat a little afraid and stuff of that because of this last incident a few days ago.
Okay. Do you want to have any further contact with her?
No, not if I can help
So
it.
right. So you don't want her to be residing there while she's on bond right now, correct?
No, not at all.
Okay. And you're how old?
Um, uh, I'll be 80 years old in December.
Good. I usually ask you how many years young, so let me not make you feel bad. 80 is a great age, and you're blessed to make it that far, I tell you. So
I tell people all the time that I've been blessed. I tell them that all the time.
correct. And are you retired?
Yes, ma'am.
Okay, good. All right. Well, we're going to try to make sure you can be safe in your home. And you've been there 30 years, so.
But I do have a question about what do I do about her son being here?
How old is he?
He's 21, 22, somewhere along that, I think.
Are you in fear of him?
Not at this time, you know, but I only is I don't want either one of them here.
And you were just letting him stay with you?
Well, basically, it's an invasion, basically.
Say that again?
I said basically it was just an invasion, basically. They came and
Oh, they came to stay and then they wouldn't leave.
no, what I thought she was coming for a day visit, which I thought she's coming for a visit and leave, but she never have left.
And so you think her son may be, upset with his mother in jail and getting out or whenever? And so
That's possible. I don't know.
yeah, I wish that I could do something about it. I would say that maybe, I don't know, how long has he been there? About a year as well?
I mean,
Say that
I don't
again?
think he's been here. I don't think he's been here quite a year. I have to go ask my other son approximately how long has he been here.
But you can't seem to get him out of your house, huh?
Yeah, that's all I want. I want them young.
Yeah.
Sorry to interrupt, Judge. He also he filed an eviction for the victim and her son, and it's actually in the writ of possession stage. So
Good.
it's just waiting for the marshal to come out and serve it.
Oh, wonderful. And I was gonna kind of send him to legal aid, and they help the senior people in our community with such matters. So I was
Sounds like
getting
it
there,
needs
but it
to
looks
just
like
be
he's
served.
done that. Yeah. And I'm so glad you all were able to get him on the phone. Thank you all for that, State. All right, Mr. Jenkins, you don't have any other questions, but the victim witness advocate, she will answer any other questions that you have. I'm going to order Ms. Jenkins to not come back to that property for now while she's on bond, but continue with your dispossessory case. And he may already be gone.
I'm not.
Huh?
I'll explain it to him, Judge.
You explain it to him. Good, thank you.
You're
All
welcome.
right. Thank you. All right, so on this case, it's a $1,500 surety bond. I think I already said that. But now I'm going to order no further contact with Mr. William Jenkins, the victim. Stay away from that property, Ms. Jenkins, and I'm not for sure about your answers to the court, but they don't seem to be truthful. So you are not to have any further contact with Mr. William Jenkins. You can have a one-time law enforcement or police escort to go back to that property to retrieve your belongings and hopefully retrieve your son. He doesn't want either of you there. And so please find somewhere else to live. No drugs, alcohol, weapons, or guns while on bond. Anything else, counsel? Either? Did I leave out anything? And remember, Miss Jenkins, you're to stay 200 yards away from him, right? You're on bond with no further contact. Be 2 football fields away from him. You're not to go by that house. You're not to call him or anything or talk to him, or else he can just call the police and have you rearrested. All right. Thank you. Next.
Next is position 12, Mr. McCoy.
Okay. This is 25 CR 002703Y. Michael McCoy charged with 1 count of willful obstruction.
24. He's a resident of Dayton, Ohio, according to the booking. On parole, possession of cocaine. Got an open DUI out of Paulding County, 2017 contempt of court, 2016 FTA, pointing pistol at another, theft by taking conviction. That's it.
Okay.
Your Honor, this incident date happened yesterday at 2789 Allegro Drive, Northwest in Atlanta. It looks like officers were trying to serve a TPO on this defendant. That's 25CV006622. Petitioner in this case would have been Letitia Michael, Letishi. They spoke with her upon arrival. She was standing outside. Because she said she was scared for her safety. She believed the defendant had a warrant and firearms in the home. When officers ran his name, he did have an outstanding warrant. They, I guess, tried to circle the house. He came out of the front door, so officers gave verbal commands for him to get on the ground. Defendant tried to run away on foot and fled the scene. Officers chased him. Looks like he ended up losing his balance on the hill. Officers caught up to him. I don't believe we spoke with Ms. Moore. I'm just double checking to make sure. Yeah, we didn't. But in any case, the state is looking for a $2,000 surety bond in this case. We're going to ask for a stay away from that address, seeing as though they were going to serve a TPO on him anyway regarding the, I guess, the victim in not in
Hopefully they can serve him now in jail.
Right. And we're going to ask for no further contact with Letitia Moore since she was a petitioner, and then no drugs, alcohol, or weapons while on bond.
Okay. PD Chataya.
Yes, Your Honor. My client would like to ask for the lowest surety amount that's reasonable. He's 51 years old. He tells me he's been an Atlanta resident for the past 11 years. Currently, he's in college now in Smyrna, and he tells me that he can't miss any days or he might fail the semester. He's working on getting his HVAC license, which is very important to him. And for the past year, he's worked as a food delivery driver on the side while he's going to school. So for those reasons, I asked the court to consider the lowest bond amount possible.
Your Honor, I just wanted to confirm really quickly, maybe the defense knows, is he being held on the probation violation out of felony court? It looks like I had that listed, that this came up as a parole violation. Do you know, Mr. Shatai?
No. Well, if you have it, it's on Odyssey.
Yeah, it was in his GCIC. It stated it had the same incident date that he had a parole violation. So he I'm guessing they would have saw him this morning if they got to him in felony court for, I guess, the same thing that triggered a parole violation. So he's probably going to be sitting anyway.
All right. Did you see that pretrial at all?
Yeah, he got a parole violation.
Okay. All right. I
A
will
parole
order that.
hold, I'll say that. A parole hold,
Parole
not a
hold.
violation. Yeah.
All right. The 2,000 surety. Stay away from the incident location and anywhere that Miss Letitia Michael might be home or work. I have no further contact with her. No drugs, alcohol, weapons, or guns while on bond. That's it. You have a question about your bond condition? About all I can answer.
The parole hold, whatever. You know, they didn't tell me I had a hold. I'm wondering, do I gotta go to court for that or be seen for that? They just only told me, they gave me my TPO and I got in.
Oh, they served you with the TPO? They'll give you information if you have a court date with that. The jail will let you know about your next court date on that.
Okay.
All right. Mm-hmm.
Next is position 15, Mr. Parson.
This is a first arrest.
Thank you. 25 CR 002709G, Jalen Parson, first arrest, charged with 1 count of simple battery, family violence, 2nd count of battery against a female who is pregnant. State.
Sorry, Your Honor. It looks like incident date was yesterday at 4555 Washington Road in Atlanta. Officers were dispatched to this address regarding a domestic dispute. They spoke with the victim, Nakia Green, Nakyha, Green, traditional spelling. She stated her and the defendant were lying in bed. The victim is pregnant. She was scrolling on TikTok. She thought the defendant was sleeping. She stated she thought she heard him pass gas. He assumed it was her. And then they started getting into an argument when she tried to tell him it wasn't her. He didn't believe her. She thought he was joking, but then he started getting physical and placed his hands around her neck. The warrant states that he was choking her, and then when she tried to leave, he pulled her arm and then choked her a second time and then punched her in the side of her torso. Our office did have a chance to speak to the victim. She's saying the same thing about how the argument began. He became upset, turned her on her right side, placed his hands on her throat. She's saying it's without pressure, but nonetheless, he placed his hands around her throat for something so small, inconsequential at that. But she said she believed it was meant to scare her. She asked the defendant to remove his hand, and he did. She attempted to get out of bed to go to her mother's room. I'm not unsure. I guess she can advise her whether this is her mother's house they're both residing in. Defendant tried to prevent her by holding both of her wrists. She asked him let her go this time. He refused. She said that she hit him and that he became angry and then struck her in her side. Nonetheless, she's still pregnant. Defendant knows that. Then she called the police and she ended up going into her mother's room. She did decline EMT assistance. Sorry, the statement is a little bit long. She said it was the first time something like this happened and she wants defendant to attend anger management classes. And she is on Zoom, so we can sound for her in accordance with Marcy's law when appropriate. Nonetheless, the state is looking for a $2,000 surety bond. We're going to ask for no further contact at this time, just to give a cooling off period and just the alleged allegation of him even placing his hands on her throat. We're going to ask for a stay away from this address. I'm going to ask for 2-day anger awareness, no drugs, alcohol, or weapons while on bond. If we could sound for Ms. Green in accordance with Marcy's law when appropriate. Thank you.
All right, Ms. Green.
Yes.
Turn on your camera, please. Or let me ask you, do you wish to address the court today? Yes or no?
Yes, ma'am.
Okay, you can't come on with any rags or things on your head. You have
Okay.
to remove. You are actually in court.
Okay.
All right. I need to
Mhm.
see you. I'm only seeing from nose up. Are you dressed appropriately?
I am.
Okay. Let me see. From this angle, not. Do you have anything to cover up with? Mm-mm.
Huh?
Jacket or shirt, something,
I'm
blouse
trying to
put
get a
on?
towel.
Okay. I'm gonna ask you to turn your camera off. We're not trying to look at your apartment. Are you ready?
I'm wrapping it around.
Okay. All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. And let me ask you this. Are you in fear of Mr. Jalen Parson?
No.
Do you want to have any further contact with them?
Yes.
You all are in a relationship.
Yes, ma'am.
You're pregnant.
Yes, ma'am.
Okay. And when are you due to
December
deliver?
6th.
Okay.
No.
All right. Any cross-examination from the state or Mr. McLean?
Is this your mother's house or is this your apartment that this incident happened at?
Yes, this my mother's.
Oh, so you live with your mom?
Yes, ma'am.
And does he live there, the defendant?
Yes, ma'am.
Okay. All right. Anything else? No, that's all the questions we have for now. You can hang on to hear the ruling of the court. All right. Go ahead, Mr. McLean.
Thank you, Your Honor. Jalen Parson is 22. He has been through most of the 12, and his last 3 jobs in the last 5 years consisted of being a cook in a restaurant. I don't believe he's got a record, and we would ask the court for a signature bond.
All right. I will grant a $4,000 signature bond through pretrial. 2,000 on the simple battery and 2,000 on the battery against a female who's pregnant. That's a total of 4,000. I'm going to order no further contact right now with Ms. Parson. I'm going to order him to stay away from the incident location, the 4445 Washington Road. He is not to go back there. If he needs a one-time police escort to return to retrieve his personal belongings, he may do that, but only with police escort. He's not to contact her by phone, stay 200 yards away from her, no emails, no contact whatsoever. At her job, home, work, wherever she may be.
Your Honor, not to interrupt you. You said Miss Parson, you mean Miss Green?
I mean, Miss Green, I'm sorry,
I
Miss
just wanted
Green.
to make it
Thank you.
clear.
No, it should be Nakia Green. Yes, no contact with her. Stay away, no drugs, alcohol, weapons, or guns while on bond. And that'll be the order of the court for today.
I had a question.
Yeah,
Where do we work at the same job?
not good.
Okay.
Do you all work at the same job?
Yes.
You all work the same shifts?
Yes.
Well, hopefully he wouldn't harm you in front of other people who witness it.
Okay.
So what I'm going to do is say that the only time he can have limited contact with you is if you all are working the same shift. Other than that, because you will be in public and among other people, I assume. Where do you all work?
In the airport.
Oh, do you have to see each other even if you're on the same shift?
Yes, we work in the same. Cause like he stated, he's a cook, and I do both. I'm a cashier and I'm a cook, so I'm wherever they position me at.
Okay, I hope he gets a
But
hold of his emotions.
I
Huh?
can talk to my manager about staying up front. I can talk to her.
Well, because if he doesn't, he's going back to jail if he gets out
Yeah.
on bond. I'm going to also order, which he will because it's through pretrial, a 2-day anger awareness course to take through pretrial
Okay.
as well. So yes, let your manager know that he's out
Okay.
on bond. You may have to give her a copy of the order and get
Okay.
that from the advocate, and get you a copy of it.
Okay. Thank you.
Okay, we just want you to be safe right now.
Okay. Thank you.
All right, thank you.
Let's see what level.
Level 1. Thank you.
Next is position 13, Mr. McCray.
This is 25 CR 002706J Lewis McCray, charged with 2 counts of willful obstruction, 1 count of fare evasion. And
21
looks, yeah, 21.
on
Okay.
probation for battery out of state court as of this year. 2017 FTA, 2015 FTA, 2014 simple battery conviction, 2013 and 12 FTA.
All right. State.
This incident happened yesterday, 641 West Peachtree Street Northwest. This is the North Ave MARTA station. Defendant, I guess he did evade the fare by walking through the gate behind another person. He was drinking an open container of alcohol known as beatbox, according to both of the officers. When they attempted to arrest him, he tried to run. The state is looking for, I'm gonna ask for 1,000 surety on each willful, 2 different officers, and 500 on the fare evasion, and then 500 on the certain acts prohibited. I believe that's a total for $3,000 surety, and we're gonna ask for a stay away from all MARTA stations, no drugs, alcohol, weapons while on bond.
I'm sorry, I didn't read that other, I think it was on the next page, the last charge, certain acts.
Certain acts, it says bus, rail, station prohibited. I believe that's the open container that they're alleging to
Oh,
that.
that's what that. Yeah, I think I forgot to read it though. I thought it was only 3 charges, but there's 4. Okay. Go ahead, PD McLean.
Thank you, Your Honor. Lewis McCray is 33 years old. He's from Georgia. He's got his Georgia ID. Lives in East Point. Staying away from an armor might be a problem in terms of access. He works as a cook at Georgia Tech, the dining hall. He's worked in the past in selling footwear, and he is a high school graduate, and he's a local person. We understand what the arrest record was listed as. We would ask the court to give a signature bond if possible. If that's not possible, then a 1,000 total.
Is the MARTA station his job or near his house? Is that the only station?
Well, the station you mentioned is about 3 blocks due east of the dining hall that he works at. So I imagine that's probably the one he would pretty much have to use. North Avenue MARTA station is right by the old Life of Georgia building and the varsity.
Well, he'll probably have to ride the bus. I don't want him to go into the MARTA station. The problem is, they have to be free to do their jobs and people have to be safe riding there, especially if he was drinking as well. Couldn't wait till he got home. And there are a lot of ride sharing things he can do. But I don't want to put him back on MARTA, at least at that train station. I get, it makes no sense to say ride to others and then get off and walk from somewhere to where he needs to go, whatever the station is prior to North Avenue. So if you figure out some other kind of way, it's probably eventually gonna be banned from MARTA. He keeps up this way. So I'm gonna order the 3,000 surety because of his history. And stay away from the North Avenue station, ASG Dunlap, I guess. Ugh.
Yeah, that's what I was saying. It's kind of
Kind of
hard
weird
if
to
he's
say
on the
that,
train.
because once he's on, isn't he? And he's gonna probably ride to where he needs to go. This is temporary to teach him a lesson. Stay off MARTA right now. So you figure out how you get to work. If you make bond, better get a ride. And find some other way. Stay off the MARTA train system. Let you ride the bus, get up earlier and take 3 buses and get there the same way. Okay? So no riding on MARTA transit trains, I guess would be the better word. But he can ride on a MARTA bus, and hopefully he won't have any incidents. No drugs, alcohol, or weapons or guns while on bond. And I think that's it. Is that it? Anything else did I leave out, Council?
What was the breakdown on the charges?
Oh, 1,500 on each will make 3.
There's 4
You
charges?
got it.
Oh, wait a minute. This is the one with the 4. I'm sorry. Hold
Yeah,
on.
I
You
had
know
asked
what?
her.
I'm sorry. I had my notes and then I had the one that I didn't have. All right. So the certain acts is 1,000. Fair evasion, 1,000. So that'll be 4, 1,000 on each. 1, 2, 3, 4, 4,000. Correct?
Correct.
You can tell it's Friday. It's been a long week because I cannot add worth a darn today. All right, 4,000. Is that right, Mr. Jordan?
That's what I have,
Okay. I know when he comes on camera, I have not added correctly.
Now, if your honor were to make it 500 on each of the obstructions, that would be back to the 3,000 the state asked for.
So I'll stay to my thousands. He had, let me see, with his history, he had 21 cycles and he's on probation for a battery. I'll stick to 4. Thank you. Next.
Next is position 17, Mr. Swiger, sorry.
$25 CR 002714Y John Swiger, charged with 1 count of driving, hit and run. 2nd count reckless driving, 3rd count driving while license suspended or revoked.
18/2023 DUI obstruction, suspended license. 2 probations from 2017. Got an ag assault battery DV from 2017. 2015 suspended license conviction. 2015 endangering a child by DUI and DUI conviction. 2012 suspended license conviction. State.
Thank you. Is that driving? I have a DUI, driving with suspended license, local obstruction of 2025. That's open, right?
From 2025.
Yeah, I had
Mhm.
2025.
What date was that?
I have to double check. It was recent, but
Because this one is 2924. Well, this case is in 2024. I just noticed.
Swiger.
Can you check that in Odyssey?
Mm-hmm.
Because this incident date is from February, apparently. It happened in Piedmont and Pelham Road.
I got
You got it?
the last arrest I got was 2017. I'm sorry, 17th cycle was 2023, the DUI.
Oh, not the 2025?
I'll double check that at the end when the defense is giving their.
Okay,
Hold on.
okay.
Okay, so defendant was driving at a high rate of speed. He changed lanes at the last minute without signaling, checking to see if it was safe. He ended up striking a vehicle that was occupied with a father and his two minor children, damaging the rear of the vehicle, then hit it. The car spun out of control, hit a utility pole, and then tried to continue to operate this car on the road. The victim in the car was Mr. Mandel. Two minor children were 5 and 7. He got out of the car and tried to, I guess, just casually walk away after, unaware of what his state of mind or what was going on when he did all of this. Nonetheless, with his driving history, and it looks like he's already, like I said, being charged with driving with a suspended license or revoked once again. The state is looking for a $4,500 surety bond. I'm gonna say $2K on the driving hit and run. And then 500. I'm gonna say 500 on the license, the driving without a license, and then 2K on the reckless. And then we're gonna say no driving without a bad license, no drugs, alcohol, or weapons while on bond. And I'll check on that 25 case I had.
All right. PD McLean?
Thank you. Mr. Swiger is, although it said Newport VI, that's, the computers was wrong. He's from Newport, Virginia, but he was born there. He's been in Georgia for a long time. He's 40 years old. He's got a Georgia ID. High school is Bainbridge, Georgia, down there in South Georgia. I believe 2023 will be that Gwinnett thing. Your Honor, what he does for a living, he is a road construction crew supervisor. So he organizes, schedules, and sees the activity going on. He doesn't lay the pavement itself, but he's got a crew that he schedules and makes sure they get that stuff done. He also takes care of his father, Your Honor. His father is in a hospice situation in Mr. Swiger's home. And an aide and a nurse, an aide comes twice a week, a nurse comes twice a week. So that's how they set up hospice for his dad. And he'd like to get back home. So we'd ask the court to consider giving him as low a bond as possible under the circumstances, including that arrest history.
I did double check this. It was originally, these incidents were from 2023. It looks like it was binded over to Gwinnett County after Snellville for some reason. But I guess I was more so asking, were those still open?
It looks like they are.
So defendant was aware he was not supposed to be driving when he hit a car with a parent and two minor children inside.
Could have gone a different way. I certainly have sympathy for his home situation with his father in hospice, but I don't have any sympathy for his driving record and 18 cycles, because at some point it'll end up killing someone else or himself. So we've got to get a handle on his life here. DUIs and no license. So he's going to have to do like the other defendant, ride the bus to and from work or do something, but not drive a car, because it looks like his license is still suspended, right?
I mean, the charge is driving with a suspended license. So
It's still, yeah. So he's not supposed to be driving. I don't know what he's going to tell me. He's probably going to say, oh, that got dropped and I have my license. I don't know what he has to say. Mr. McLean, do you want him to talk or not?
I don't mind them talking if it's a question about bond procedures. If they want to talk about the past factual basis, I'd rather save that for a plea bargain and trial.
Well, I was just saying my license reinstated in September of last year with Intoxilock box in my truck. Unless something's happened since then, I'm not aware. I've not been notified by the DDS.
Very good.
Well, that's what he says. I'm gonna give him a $3,500 surety bond, 2,000 on the driving, hit and run, 1,000 on the reckless, and 500 driving on a suspended license is what they say. So that'll be 3,500. No driving unless he has a valid driver's license. I guess you need to check it. And no drugs, alcohol, weapons, or guns while on bond. Yes,
Just so the
ma'am.
defendant is aware, they ran a Georgia DMV check on the status of your license and it is suspended. It's been revoked.
Okay. So be careful because you'll be back down here. If they catch you driving again.
And it says he has a lifetime commercial license suspension as a result of multiple DUI convictions. In addition, there's a license revocation of his license as a result of the same DUI convictions, resulting back to 2018. So he should not be driving.
Okay, no driving. All right, thank you.
Next is position 18, Mr. Thompson.
Okay. 25 CR 0027165, Michael Thompson, charged with 1 count of criminal trespass and damage to property, 2 counts of battery, family violence, and 1 count of simple battery.
State, what's the victim name in this case?
There's 2.
Is one of them Carter?
Yeah, and he was seen for a case with her earlier.
So that case, judge ordered no further contact with Carter. Carter gets to stay at the house since she is the leaseholder, from what I was told. And he stated on felony that he has somewhere else to stay. So he got a good bond in that case. 2017, I'm sorry, 17 total. 2023 simple battery DWAP. I think that was the same victim. And a 2012 failure to appear. The felony charge was theft by taking. That's all.
Thank you.
This incident date is from 2 days ago on the 14th at 550 Abernathy Road, apartment A-568 in Sandy Springs. 2 victims in this case. The one from earlier in previous cases, I think it's Jurashika. I'm going to spell that Jerushika. Last name Carter, traditional spelling. Additional victim Brooklyn Thompson. I have it spelled as Brooklynn. Last name Thompson, traditional spelling. That's the defendant's daughter. This first victim is I guess the spouse or girlfriend, and they have children together.
It's the child's mother.
I don't think this is Miss Thompson's mother, but yeah, I didn't have any information relating to that. We only got the warrants in this case.
Okay.
So I could just go based on what the simple battery is for him splashing an alcoholic beverage on the victim's chest, Miss Carter. The criminal damage to property is for him damaging the bedroom door inside the apartment belonging to Miss Carter, breaking it off the hinges. They live together, have children together. Defendant struck Miss Carter multiple times with his fist upon her body. He caused bruising, scratching to her chest and right and left biceps. Second victim, Miss Thompson, defendant's daughter. He punched her in the jaw, causing visible injuries, swelling, and attacked her. I didn't have, like I said, the report, so I don't know what the backstory is to how all of this started, just with basically the allegations are. Our office did speak with it looks like a Cheyenne Thompson, the victim's daughter. I am unaware how old she is. She stated she witnessed the incident. She confirmed that she witnessed the incident. She stated that verbal altercations between the victim and defendant and herself are common. However, during this particular incident, defendant escalated the situation by she's stating allegedly pulling a knife on the victim. They called another number. A different woman answered the phone and stated the victim wasn't available at the moment. She was seen in felony court earlier today as well, on alleged charges involving him. Like I said, I don't have the report, so it's unclear like how they were both arrested, how this incident started, just that he had violence against more than one person in this case. So the state is looking for, given that they have previous incidents with Miss Jerisha Carter, we're gonna ask for $8,000 surety. So I'm gonna ask for 2 on each charge. No further contact with both victims. Like you said, the felony court issued no further contact. Stay away. He said he has somewhere else to go. We're gonna ask for a 2-day anger awareness or FFIT, whichever the court is inclined, and no drugs, alcohol, or weapons while on bond. And I guess we can sound for Miss Carter or Miss Thompson when appropriate if they had a chance to join the Zoom. Thank you.
All right, Ms. Carter or Ms. Thompson, Jerishka maybe, or Brooklyn Thompson. Nope.
Jerisha, she's not gonna be. She's in custody. She's not gonna be in court.
Apologize for that.
She got the ag assault. Let me see what her bond was real quick.
And also,
Mhm.
Judge, the daughters in the case, they are at graduation.
Oh, a lot
I
of
ain't put it
graduations
in.
today.
It's not updated yet.
Okay. All right, go ahead, Mr. McLean.
Thank you. Mr. Thompson's 57. He's a Georgian. He's got 11th grade education, and he has worked as a forklift operator in a warehouse. Did that for quite some time in the last several years, Your Honor, because his back is out and his knee is out. He's on disability now. So he's been a hard worker, and he has a serious disability now. But his situation is one where he would ask the court to consider the lowest possible bond. A signature bond is possible, but if that is not possible, then he would ask the court to consider no more than I would think, let's see, 500 on the damage, 1,000 on the battery, family violence, and 500 on the simple battery. Thank you.
There's 2 counts of battery, Mr. McLean.
Yes.
All right, I will order $7,000 surety bond, 1,000 on the criminal trespass and damage to property, and 2,000 on the 2 battery family violence, 2,000 on the simple, 2, 4, 6, 7. So 7,000 surety. Again, I'm gonna say it one more time. Stay away from and have no further contact with the 2 victims. Stay away from their home, work, no further contact. No drugs, alcohol, weapons, or guns while on bond. That's it. I don't know if he has a question about bond conditions, but
I can call the courtroom. I think it was my last case.
yeah, that was the last one.
No, he doesn't have a question
Oh
about.
no, I think we have a waiver one. Who was the waiver on? Position 11.
Positions 9 and 11 are waivers.
Oh, 9 as well. Okay.
9 and 10, sorry. 10 and 11.
No, 10 was Jenkins.
We had
9 and
2.
11.
There's 2 Jenkins today. Cartier Jenkins.
Oh, I see.
9 and 11.
9 is Jenkins. 9 and 11. Yeah, 9 is Jenkins too. All right. I'll do number 9 first. 25 CR 002694E. Is that Cartier Jenkins? Charged with 2 counts of willful obstruction, 1 count of possession of marijuana less than an ounce.
I got 19, 3 probation holds, 1 without a Gwinnett, has FS charges. 2021 felony theft by taking conviction, felony theft by receiving, 2021 FTA, 2023 fleeing an officer, theft by receiving. You get it.
Okay. Did we lose her? Oh, there we go.
Thanks, Your Honor. So this was a case that was reset from yesterday.
Oh, okay.
Is that what we're talking about, Mr. Cartier Jenkins?
Yes, that's it.
This is a obstruction, 2 counts of obstruction and a misdemeanor possession, Your Honor, of marijuana.
Mm-hmm.
Pull it up. Do we know why it was reset from yesterday?
I remember. Yeah, it was I think behavior, right?
Who,
He
he
didn't
was
want to
on
come out.
yesterday?
He didn't want to come out. Is this the one that didn't want to come out, didn't want to come to court? It's behavior. Is this the
Yeah,
one?
yeah, it is. I just seen the calendar.
Okay.
Mm-hmm.
This is an incident from the 13th of May at about 8:30 p.m. Takes place at 2423 MLK Junior Drive Southwest. Police responded to the area when the defendant was identified as a wanted person with 2 full extradition warrants for probation violations out of Fulton and Gwinnett County. He was seen getting into a blue Nissan, and that Nissan left from the location there on MLK, traveled to the Chevron gas station at MLK as well. Right. The defendant was seen going inside the location. Officers went inside the location to make contact. He immediately started to pull away from officers when they tried to detain him. He actually wiggled out of his jacket and took off, tried to get back in his blue Nissan, then changed his mind and decided to go on foot back to the 2423 MLK Junior Drive. Disregarded verbal commands to stop, jumped a railing, tried to hide behind it, was taken into custody. He was found with a small amount of marijuana. Based on the criminal history, Your Honor, the state's requesting a surety bond. We'd be requesting $3,000, one for each of the counts. No drugs, alcohol, or weapons.
All right. This case. Chataya. Okay.
Yes, that's my case, Your Honor. My
Mhm.
client is 23 years old. He's a lifelong resident of Atlanta. He's been through school as far as the 11th grade, and currently he's unemployed, but he does tell me that he would like to work at the dollar store, the Dollar General store, and he's been trying to get employment there. For those reasons, Your Honor, given his strong ties to the community, I would ask this court to consider the lowest surety amount that's reasonable.
All right, I'll give the 3,000 surety, given his history. 1,000 on each, no drugs, alcohol, weapons, or guns while on bond. And to oh, I guess there's no stay away. What was that at that address? ASG Allen, I don't know what that was.
You know, I'm unsure. The defense could tell us if that is his residence.
Or what is that? Or
MLK.
seemed like it was a business, but I'm not sure. Do you know? PD Chataya?
I'm not sure, Your Honor. I asked him if it was his home, and he said no. So,
Well, let's just say stay away, whatever it is. It's something. It's not the middle of the street, but as long as it's not his home, then he can stay away.
It is right. His home is a Stone Mountain, Georgia location, not 2423 MLK.
Mm-hmm. Okay, let's just say stay away.
Thank you.
Mm-hmm. And then position 11. This is 25 CR 002713B. Quinetta Jones charged with 1 count of simple assault, 1 count criminal trespass, 2
Your Honor,
counts of threats,
last bond amount.
1 count of terroristic threats. So that's 1, 2, 3, 4, 5 charges.
Your Honor, can you repeat position number 9?
Okay. 9 is $3,000 surety bond, 1,000 on each. Stay away from incident location.
Jones, 27, on probation, simple battery in a public transit vehicle or station. 24 CR 003-170B. Her last 4 arrests were on Marta, and her history consists of trespass, simple assault, and simple battery.
You had 27 cycles?
She does. Jones, right?
Yes.
Yes.
Okay. All right, state.
Yes, Your Honor. The state was asked for $1,000 surety bond for a simple assault, $500 surety for the criminal trespass, and $300 surety for each count of the certain acts. Bus, rail, station prohibited. Incident date is May 13th, 2025. And on May 15th, the officer met with the victim in this case, Rhonda Allen, who was employed by Marta in order to obtain a written statement regarding an instance of simple assault that occurred on May 13th, the incident date. The victim stated while she boarded the southbound train on the north lead car, she noticed the defendant came aboard the car through the emergency door. Now, the defendant appeared to be agitated and was talking to herself, and the defendant approached several patrons for money. Afterwards, the defendant asked the victim for money, who then flashed her Marta identification badge. The defendant aggressively approached her within a foot of her face, put her hands near her face, and threatened her by saying, "I'll kick your expletive." Another passenger stepped in between them. The defendant went back through the emergency doors to car 165, and she has a permanent ban from Marta. And I think that was ordered back in September 2024. From what I can tell in our office's research, she's homeless, but has numerous arrests and convictions regarding simple battery, and criminal trespasses, ranging from 2015 to 2025, so the last 10 years. I've noted FTAs and 2 FTAs in 2015, one in 2019, another in 2023. State's asking for no further contact, of course, with the victim here, Rhonda Allen. Stay away from Marta, as already previously stated, and no alcohol, drugs, or weapons while out of bar.
All right. Did you say on the last 3 charges 300 each or 500?
Yeah, 300 each.
300 was your recommendation. Okay. Which one? McLean or?
This is also my client, Your Honor.
Okay.
Ms. Jones is a 30-year-old lifelong resident of Atlanta. She's been through school as far as the 12th grade, and she currently does not have a job and has not had a job in the past 5 years. And she did tell me she was homeless, but she declined any assistance. I asked her if she wanted a social worker visit, and she said no. So given her unstable situation and that she probably wouldn't be able to afford the bond that the state is asking for, I ask this court to consider the lowest surety amount possible.
All right. I'm going to go with the recommendation by the state. That would be 1,000 on the simple assault, 500 on the criminal trespass, and 300 on each of the certain acts. It should be a total of $2,400 surety. Is my math right, Mr. Jordan? No further contact with the victim, Wanda Allen, and again, stay away from Marta and adhere to the permanent ban.
That
No drugs,
victim's name,
alcohol, weapons, or guns while on. Go ahead.
the victim's name is, I think, Rhonda, RHONDA.
Oh, Rhonda, not Wanda. Not a
Yeah.
W, but an R. Okay.
Yes.
You checking me, Mr. Jordan?
Oh, no, it was good, Judge.
Okay. All right.
We're done, right?
Yes, that should be it.
Position, oh, sorry. Position 1 is a $1,200 surety, reset SAP 529.25. Position 2 is a $3,000 surety, reset SAP That's 1,000 per charge. Position 3 is a $2,500 surety, reset SAP, 2,000 for count 1 and 500 for count 2. Position 4 is a $2,000 surety, 1,000 per charge, reset SAP. Position 5 is a $14,000 surety, reset SAP. That's 9,000 for the battery family violence and 1,000 for each additional charge. Position 6 is a $4,000 surety, reset SAP. That's 1,000 for count 1, 500 for count 2, 1,500 for count 3, and 1,000 for count 4. Position 7 is a $2,000 surety, reset SAP. That's 1,000 per charge. Position 8 is a $2,000 sign-on bond pretrial level 1. That's 1,000 per charge. Position 9 is a $3,000 surety, reset SAP, 1,000 per charge. Position 10 is a $1,500 surety, reset SAP. Position 11 is a $2,400 surety, 1,000 for count 1, 500 for count 2, and 300 for each additional charge. Position 12 is a $2,000 surety, reset SAP. Position 13 is a $4,000 surety, 1,000 per charge, reset SAP. Position 14 is a $10,500 sign-on bond pretrial level 2 per judge. That's $250 for the possession and willful obstruction, and $10,000 for the possession of a pistol with a co-signer. I'm getting right now. Position 15 is a $4,000 sign-on bond pretrial level 1, 2,000 per charge. And position 16 is a $1,000 surety, reset SAP. Position 17 is a $3,500 surety, reset SAP, 2,000 for count 1, 1,000 for count 2, and 500 for count 3. Position 18 is a $7,000 surety, reset SAP, 1,000 for count 1 and 2,000 for each additional charge. That's all I have.
Okay.
Any corrections?
Question, Mr. Jordan. Position number
Yes.
7, I thought it was a surety bond. You said SOB.
Let me go
Hold
back to
on.
y'all. It should be a surety. Davis,
Correct.
it was 2,000 surety, 1,000 per charge.
Okay, because you said SOB.
Oh, my bad.
That's okay.
It
I
was a
guess
long
none
day.
of us heard him, huh?
Well, thank you for paying attention there, Miss Gordon.
Thank you. Yes, it's Friday.
Everybody else
Everybody.
like, get it over with.
Okay, right.
Thank y'all so much.
All right, everybody
Yes.
have a good weekend.
Have a good
Have a good
weekend. Judge, are
weekend.
you gonna be with us on tomorrow?
No, ma'am. No, ma'am.
Right.
No, ma'am. Yeah,
Good.
Law and I switched, so she'll be
I'll be in
tomorrow.
tomorrow. She'll be tomorrow.
Yeah. Are you tomorrow?
No, but I'll let these
Oh.
folks know who will be. I'll be the next week.
Oh, next week. Okay. All right, you all take care.
Judge Mincy, this is our newest ASG, Mr. Nixon.
Yes, he did very
wanted to
well
introduce
today,
you.
Mr. Nixon.
He's gonna
Yeah,
do a
I think
great
I met
job.
him at the other one, so today he got to do lots of talking.
Yeah.
So very good. You did
I
well.
appreciate it.
Thanks,
It's great.
everybody. Have a wonderful
All right.
weekend.
You too. All right. Bye-bye.
Good job. Have those to you in about 5 minutes.
Yes, sir. Thank you.
All right.
I can't get it to click. Leave.